on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts.
Yes.
Do you understand you are currently on probation or parole? Your probation or parole may be revoked based on your entering a guilty plea today.
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws in any governmental units or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Amen.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison? Do you understand you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? And Mr. Eppinger, I'm going to ask you to say yes, after each right that I will
Well, say yes if you understand that that's a right that you're giving up and you want to give that up. Say no if that's not the right answer. Say I don't understand if you don't understand. Okay?
The right to a trial by jury.
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses and witnesses.
Yes.
Your right to assist with counsel hired by you or to court-appointed counsel if you cannot afford an attorney in a trial in your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have a charge against you proved beyond a reasonable doubt.
Yes.
The right to appear if convicted of these charges after the trial. Has anyone forced, threatened, or promised you anything to get you to enter a plea of guilty?
No.
It is my understanding that you're asking the court to consider this plea under North Carolina versus Alford.
Yes.
And is that every count that he's going to be pleading to?
Yes, Your Honor.
All right. Well, I'll have to hear why.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty, or are you pleading under, or asking the court to plead under North Carolina v. Alford?
Alford.
Are you pleading guilty because you have decided it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and place you in the same position as if you were convicted by a jury at a trial?
Yes.
Now, Mr. Eppinger, based on the negotiations, do you understand that you are pleading to the following counts?
That the state's going to move, as a part of this plea, going to be null crossing certain counts?
Yes, sir.
All right. What is the state moving forward on?
Your Honor, the state is moving forward on count 1, conspiracy to violate the RICO Act. Count 27, armed robbery. We are going to null cross count 28, hijacking a motor vehicle in the first degree. We're moving forward with count 29, possession of a firearm by a first offender probationer. We're moving forward with count 31, theft by taking. Count 32, attempted murder. Count 33, attempted murder. Count 34, possession of a firearm by a first offender probationer. We are null crossing count 35, possession of a firearm by a first offender probationer.
Count 35 was previously dismissed, so we're not no crossing that count.
Oh,
Excuse me, Your Honor, during the first charge. Count 36.
wait, back up. What do you mean by the first
During
charge?
the first series of the case, Your Honor, that case. Count
35 was,
Yes, Your Honor. The defense, we filed a motion to have that count dismissed.
All right.
We completed it with count
all
number
right,
34.
okay.
Count 36, possession of a firearm during the commission of a felony. We are null crossing count 37, possession of a firearm during the commission of a felony. 38, his participation in criminal street gang activity. He's pleading to count 39, participation in criminal street gang activity. Count 47, conspiracy to commit a crime. And count 48, participation in criminal street gang activity. Mr. Eppinger, with respect to those charges, if I need to read them again, how do you plead to those charges to which you're pleading to?
Yes.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date for the felony, for all the felonies, to file a habeas corpus petition challenging the constitutionality of the guilty plea?
Yes.
Do you also understand you have 30 days from today's date to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion to withdraw this guilty plea, which does not mean it will be granted. That's just a time period that you can file. Do you understand that?
Yes.
And Your Honor, if this case were to go to trial,
Is this something that's on Zoom?
yes, Your Honor, the state would expect to show a number of different things as we move forward with this indictment, Your Honor. As you have heard, this is the YSL regional indictment in which the YSL gang is an enterprise consisting of a group of individuals associated with that. Although not a legal entity, they were started in 2012 in the Cleveland Avenue area of Atlanta, Georgia, and they claim affiliation with the National Blood Gang. The founders were Jeffrey Williams, aka Young Thug, also known as Slime, Walter Murphy, also known as DK, and Chartavius Stephens, also known as Slug. They identify with a variety of identifiers, including colors, clothing, tattoos, and hand signs, as well as verbal and written identifiers. They often wear clothes with the words Slime and YSL, and also have tattoos with the name YSL. Specifically for Mr. Eppinger, Your Honor, he has several cases in this indictment. Your Honor, under count 1 of legal conspiracy, Mr. Eppinger had an armed robbery in May of 2016 with the victim, Xavier Hill. He was convicted of that crime, spent 4 years in prison, and was released in May of 2021. In October of 2021, Your Honor, he did the armed robbery of Mr. Darius Smith.
All right, so did that May 11th armed robbery, did he, was that a first offender conviction?
It was a first offender conviction. It was reduced from armed robbery to robbery. And I'm going to go into more detail, Your Honor. I'm just going to give an overall timeline. In January of 2022, there was a theft spot taking. About 3 weeks later, in February 7th of 2022, was the attempted murder of Officer Rogers and Sergeant William Johnson. And then in February of 2022 was a conspiracy to stab and kill Mr. Rayshawn Bennett. Your Honor, we went over the crimes that were charged in this indictment. So again, on May 11, 2016, which is at 61 of count 1, the RICO conspiracy. This happened at 245 on Mall Drive Southwest, which is in Atlanta, Georgia, in Fulton County. The victim, Ms. Taravia Hill, was coming home that day with her daughter. Mr. Eppinger arrived in the subdivision with 3 other males in a vehicle. He got out of the car, held Ms. Taravia Hill at gunpoint in front of her daughter, robbed her, took her vehicle, and went and fled the area, Your Honor. He was picked up about an hour later off of Cleveland Avenue, where he actually got into a car crash off of Cleveland Avenue. This is some of his in the middle picture, the picture of him on social media in and around the time of this armed robbery, Your Honor. That is, the picture on our left is the area where Miss Taravia Hill was robbed, and then that is the car that he stole from her, and then ultimately got into a car crash. And at this time, Your Honor, Mr. Eppinger was going by the moniker on his Facebook page, YSL Bhris. His name is Christian, but he changed the B to a C with the same monikers that the blood case uses that he was in. As I mentioned, Your Honor, he was convicted of this crime in December 2016 with a negotiated plea. The victim, Ms. Hill, came in, understanding he was 16 years old at the time, asked for leniency for him, in which his armed robbery was reduced to robbery, and he received a sentence of 10 years instead of 4 years found on probation. Mr. Eppinger got out of custody in May of 2021. Within 5 months of that time, he was back on the block of Cleveland Avenue with his YSL associates. In this picture specifically is Durante Beebe, and Mr. Eppinger is in the middle, wearing Keep America Slime Against black clothing and all of those same monikers that came with YSL in the gang. And this is on September 29th, 2021.
And was there a probationary condition that he not be connected with known gang members?
Yes, Your Honor. Within 3 weeks of that picture, Your Honor, we had the armed robbery of Darius Smith on October 12th, 2021 at 47 Cleveland Avenue, which is also known as the Cleveland Avenue Park. This is where a number of YSL gang members hung out.
And this is going to be counts 27, 28, and, well, 27 and 29
yes,
of our indictment. Okay.
Yes, Your Honor. And while Mr. Darius Smith was at the park that morning, hanging out with a friend because he was waiting to meet his brother, the defendant, along with Durante Beebe, approached Mr. Darius Smith, holding a gun to his head and to his side. They stole his watch, his chain, his earrings, his wallet, and ultimately they also stole his white beard. This happened about 4:15 or 4:45 p.m. That afternoon. While there are kids, this is a library, Your Honor, so in the front of the park is a library, and the back is a playground area. This is just some of the surveillance video, Your Honor. So what you're going to see in this surveillance video in a few moments, we believe that the robbery happens to the left of the screen, so where the cars are coming from. And so you can't see the robbery off camera, but what you're going to see, and I want you to notice, the adult woman, they keep looking in that direction. We believe this is where the robbery is taking place. You see them rush and get into the car. And then you're going to see another young man come down the steps. And she kind of flags him and tells him to hurry. So we believe this is the point in time the robbery is ending and the vehicle that's stolen is in the background of this video. For this case, Your Honor, the state had phone records. We were able to get the phone records for Durante Beebe. He was using his phone at the time, or in and around the time of the armed robbery. Mr. Eppinger was not. What we have is, at the bottom of the screen, Mr. Beebe's phone pings in the location of the robbery, and then we see his phone pinging later on in the afternoon to where the car was recovered, which was not in the same location. The car was actually recovered at the village at Castleberry Hill, which is about 10 minutes or so from this location. This is the victim, Mr. Darius Smith. You see him wearing his chain prior to the armed robbery, which was one of the most significant pieces that they stole because his chain was very distinctive. At the time, he was a rapper. He went by the name of Trap Commander, and the chain says Trap Commander on it. After the robbery, we had Sergeant Pierre, who was the lead detective on this case, was able to get Instagram records of both Durante Beebe and Christian Eppinger. And what we found after the robbery, Durante Beebe is holding the chain, so that's him on the end. And then we found that Mr. Christian Eppinger, we believe, actually bragged about the robbery, and that's the video that's going to play next.
My time been.
Shit, that nigga had was with me.
I'm saying, I'm not, you know.
I dropped out of his ass, took everything. I took his chain, his rollers. Ooh. Ooh, no. No, that's what I did. But I knew he probably been out. Well, don't know the part.
How much I can get from
What?
from the furniture?
I want to come shit. Don't I know? Keep about that. No? So you can get 3,091st. You got them motherfuckers back. I ain't gonna wait. Might well stay.
You want to win? I got flat.
Go. What's big guy? Huh? I'll take that. I'll take that.
You see that bitch been busting outside?
Huh?
Hey, Your Honor, so in that clip, he's talking about taking the chain and he's trying to sell it back to the victim. He also talks about the watch, the earrings, and all the items that were taken from Mr. Smith. And then he talks about the fact that he put the gun to him and put him on the ground. When we met with Mr. Smith, just to understand what happened to the case, I asked him, what happened to you? He said, the defendant put me on the ground, he made me sit on the ground before taking the items. And so we believe that this is him bragging about that armed robbery. And this was posted about 4 days after the armed robbery. The next, Your Honor, we have overt act number 149. Again, Mr. Eppinger is with 3 other YSL associates, Durante, BB, as well as Mr. Mooney Lee, also known as Slime White Shorty. So again, posting pictures in the same clothing, OTS, only the slime clothing. Then he's posting on social media, Cleveland gave me the game, YSL gave me my name. We were studying back then, we wasn't studying the thing. Free ESPN, which we believe every slime plays nasty. The real ones, not the play plays. So again, him posting about the game, and then him with guns and things of that nature, this is all on his social media. Then we have January 22nd, 2022, Your Honor, which is count 31 of the indictment of theft by taking. This is at the Zaxby's on Northside Drive. The victim in this case, Mr. Willie Moore, was a Uber Grubhub driver. He was picking up an order for a customer. He walked inside of the Zaxby's, and this is the surveillance video from that incident, Your Honor. That's Mr. Eppinger in the black hoodie. That's Mr. Moore walked into the Zaxby's. You see that Mr. Eppinger turns back around, leaves his friends, gets into the vehicle, and then drives off with the vehicle. Mr. Moore did not give him permission to drive that vehicle. After this incident, a bolo was put out. Members of APD gang unit, Sergeant Johnson, they were able to immediately identify him as Christian Eppinger. The car was later recovered 3 days later by Officer Cogdale at 340 Thomasville Boulevard, which is in southeast Atlanta, with now bullet holes in the car that weren't in there previously. And then next, Your Honor, we have February 7, 2022, in which officers were doing an operation to arrest Mr. Eppinger on the armed robbery warrants from October 12, 2021. They had plans, an operation in order to get Mr. Eppinger arrested. It started off with some surveillance at a house off of Clear Drive. They saw Mr. Eppinger leaving that house. There was one officer, Storno, or investigator Storno from the gang unit, who gave information to some of the other officers that were helping with this detail. Those officers included Officer Rogers, Officer Teasley, and a number of other individuals who were preparing to participate in assisting with this incident. And let me stop. What essentially happens, Your Honor, is Officer Sergeant Johnson was able to, he was doing something else, but he was able to get to the Cleveland Avenue area within moments of this occurring. As I said earlier, Officer Storno was following Mr. Eppinger, giving updates on his whereabouts. They eventually ended up at 221 Cleveland Avenue, which is the Chevron gas station, which sits at the corner of I-75-85 and Cleveland Avenue. Mr. Eppinger walks into that store. Sergeant Johnson's able to have eyes on him to update what his movements are.
Sergeant Johnson?
We have Sergeant Johnson, Officer Rogers. So Sergeant Johnson first gets on the scene. He's able to update the other officers about Mr. Eppinger's movements. Mr. Eppinger leaves that location and begins walking towards the apartment complex, which is Colonial Drive. At that time, Officer Rogers, who's in his marked police car, is following behind. He sees Mr. Eppinger walking in. Officer Rogers then, in his patrol car, begins to follow behind, entering into the apartment complex, Your Honor. At that point in time, this is where the video picks up, Your Honor.
Right, and this is Officer Rogers' video, right?
Yes.
61, 61.
Your Honor, what you see happens is Officer Rogers in his marked uniform, Your Honor. He is in the marked uniform. He sees Mr. Eppinger. He tells him to get down, get out. He's in his marked patrol car, in his marked gear, similar to something what he has on today. He is in the courtroom today, Your Honor. When he gets out, Mr. Eppinger does not follow or comply with any instructions, Your Honor. He asks to put the gun down, get out the car. Mr. Officer Rogers actually, and what you can't see, is actually trying to go from his firearm to his taser in order to reduce force. when Mr. Eppinger takes out a gun from right underneath his arm, this is where he's holding it, turns around and begins shooting. At that time, Sergeant Johnson had came in right behind him, and so I'm going to show you this angle, Your Honor, so that you can see what actually transpires in another angle. And when you see Sergeant Johnson, that's him on the left-hand side, ducks, Mr. Eppinger returns fire back towards him as Sergeant Johnson's trying to protect Officer Rogers, because he has now shot Officer Rogers 6 times. Officer Rogers has 6 gunshot wounds, 4 to the right shoulder, to the posterior thigh, and 1 right and posterior scalp. I mean, it almost grazed his head, Your Honor, only by the grace of God that Officer Rogers is still here with us today. At that moment, officers did not wait for ambulance. They actually put Officer Rogers in Investigator Stornow's vehicle, who arrived shortly thereafter, and then transported him to Brady Hospital. Now, this is Mr. Eppinger and phone call after.
What the hell you think? I don't give a fuck about Luke work. I really want thinking, bro. That shit happened so fast, bro. That shit happened so fast, man. Uncle hopped out on me, ran out on me with me. I could see that shit. I was seeing that shit like, yeah, I'm like, that ain't Big Bhris shit. Nah, bro. That's what I'm saying. Everybody keeps talking about I'm tripping. Hell nah, they can run out on you, finna click on you, but then you gonna be. You know, bro. So what you gonna tell them folks? I ain't gonna tell them folks shit. Man, niggas. And then you start, and then you gonna tell them folks. You know what happened to them? Hell nah, boy, you funny as. I'm like, what you gonna tell them folks, bro? Listen, bro. I'm gonna hear you gonna say, cause you ain't got no explanation, boy. What they mean, man, listen. Hey, don't be running up on me pointing that gun at me, man. I might get out. I'm getting out, boy. I ain't getting out. Somebody told me they call it 12 when you ass up there. Yeah, somebody, I don't know who it was, though. Who was all up there? They said it was an informant. So, I don't know. Somebody wasn't some folks, though, son. Little problem. Somebody wants to some folks. Oh, damn. Bhris. Yo. The police, they ain't done ever. You said what? And the police, they hate you. Man, listen, you might not know my name, bro. Hey, I'm calling you like going for that shit, bro. I ain't just talking, bro. I just want to ask you, just to tell you really, based on all this type of shit you do. I just want to make sure that shit ain't, you know. Man, it's all snake, nigga. They ain't touch me. What the fuck, man? Y'all know me, bro. Come on, bro. Y'all know me, bro. I'm not going out there in or out there, bro. That's it. I said that shit too. I said, they might get Bhris not to go out for that. What? They just be talking shit like, oh, you ain't ever going home. So, when your papa shot, what? What they say you never going home? Yeah, you know they trying to get the lighter, bro. Yeah, I know. Man, you know what it is, man. Free BB, free. I ain't even trying. I ain't trying to be in my for the rest of my life. I damn sure was trying to be dead. But if you would have called me tased, it would have been different, bro. I thought it was just rain. You get it? Yeah. Man, I got scared. You get that blick on me. Popped out with a gun, not throwing later. Got that with a gun? Yeah. Big Bhris pop. Yeah. Yeah, I ain't gonna keep talking about that shit on this phone, though. I just call it. Yeah, I just speak. Hey, Bhris. Yeah, I miss y'all young niggas, though. Y'all my favorite young niggas, man. Man, look, you your ass stupid hell, man. Bhris, you don't seen that shit before I got locked up. I need y'all to do me a favor though. What's up? I need y'all to drop one of the phones right quick, bro. My shit is going up, bro. Yeah, let me go look at your face. Nah, they go look at my views on YouTube. You got a phone down there yet? Nah, nigga, ain't no phones in my street. I'm on my tablet.
So Your Honor, while on the phone, you heard
What's the worst nightmare for?
him laughing about the fact that he shot Officer Rogers, and then it's callous enough at the end, he's worried about his YouTube views going up and wants everyone to go on YouTube so that he can now be more famous for what he just did as a part of this YSL gang, which is injuring an officer while he was trying to do his duty. But it doesn't stop there because he gets praised for it.
Yeah, man, free my nigga Big Bhris, man. Yeah, man, I was saying that. Fuck that boy, strike that baby. Yeah, man, free my nigga Big Bhris, man. Fuck the DA. Yeah, we catch some fun on this shit. Yeah, we about to get that fun for nigga. We come in the kitchen. You know what it is. Yes, sir. That shit is free game. Yeah, YSL shit. Yeah. Slack bean. Slack, man. Free game. It's on the jump board. Yeah, man. Free my nigga Big Bhris, man. By the way, the game way. Big Bhris was a big hit, man. They gave my nigga a bun today, man. Scare me. They gave my nigga a bun today, y'all. Shit crazy.
And that was Rodelius Ryan, while he was in prison, posting YSL the gang way because he was receiving bond for this horrible act that he committed. And then we have on February 22nd, 2022, while Mr. Eppinger is in custody at the Fulton County Jail, which is now count 47 and count 48 of the indictment, Your Honor, conspiracy to commit murder. On February 2022, Jada Myrick had stabbed Rayshawn wife and Lucy Bennett while in custody, Your Honor. And that is Mr. Bennett on the right-hand side. And this is a screenshot of the video of that stabbing that occurred on February 9, 2022. Given that Mr. Myrick did not complete the task at hand, which was, we believe, to kill Mr. Bennett, Mr. Eppinger wanted...
Sorry, I got that poke loose ass up. Oh, no, hell no, I didn't do it. I didn't do it. I ain't do it. They already shipped your ass off? No, I'm in Rice Street, man. Oh, yeah, Rice Street. Yeah. But you they say your ass done got down pop his ass. Nah, my little partner pop.
And that little partner was Jada Myrick. But since he could not finish it, Mr. Eppinger wanted to take on the task.
Yeah, that shit upstairs though. Oh, they got me on PC with the boy Luch. Oh, they was on PC. Yeah, hey, find out what I can get for that, bro. Huh? Now, find out what I can get for that, bro. Just what? You know what I'm talking about? I know what you get for. I just told you why I'm at. Okay, so what you need me to do? Find out what I can get, man. I just told y'all the woman to go on with. We don't know it. Lucha, nigga. Oh, you in the drama? Yeah. No, I'm gonna make a call right now. I'm gonna let you know. I'm gonna let you know when you gonna make a call back. I call back anytime, bro. I've been trying to call you, bro. I like, bro. If I go, I know, and one nigga gonna make it to the straight bus, Obama gonna do it, bro. Obama gonna make it good. Man, yeah, you know that, but goddamn, I'm finna just put some, I'm finna put something in some here and see, you know what I mean? What they gonna send to you, goddamn. What you
Yeah, I know.
I need a lawyer, bro. I need a lawyer and right. Yeah, you do. And that's a big deal right now. If you get that boy, so yeah, I don't see nobody not fucking with you, bro. You handle that business, bro. That's what I'm saying, bro. I was trying to get dollar numbers so I can have a slime, man. I know I was gonna hop in about that shit on the phone, but he gonna catch a nigga drip just like you get caught. I'm gonna pull up to the Yoda tonight. Bro. I'm there for it all. I'm gonna pull up to the Yoda tonight. That bitch ass supposed to be sending me something, bro. I'm gonna pour a shot to the side for one-on-one shit and then after job. Hey, yeah, bro. They tell him my situation too, bro. I already know he done heard about it. You know I'm gonna tell him, bro. You know I'm gonna tell him I got you, bro. Yeah, who all right now?
And Your Honor, so he was talking to Antonio Sumlin on that call, and some key things that I want to point out in the call is Mr. Eppinger says, I was trying to talk to Dolly so I could talk to Slime. From the previous trial, we know that Dolly is Mr. Jeffrey Williams' sister, and Slime is the name that they call Jeffrey Williams. So it's the state's belief that he was trying to reach Dolly so he can reach Slime to find out whether or not, if he does this, can he get a lawyer? That's the only thing he was asking for payment was a lawyer. And you see here, Mr. Sumlin again has his YSL tattoo on his chest, and Mr. Eppinger has the YSL tattoo on the side of his face. Again, showing that all of these crimes are in furtherance of this gang, YSL, in furtherance of this enterprise to continue to wreak havoc on the Cleveland Avenue community and the community at large, Your Honor. So we believe that would be the evidence that the state would present if we were to go to trial on this case today, Your Honor. Earlier I did speak. He did not have, for the 16 SC case, Your Honor, he did not have a special condition stay away from gangs.
Okay.
However, what he did have was the violation of the general conditions, which he's to avoid persons or places of disreputable or harmful character, Your Honor. And then, as it relates to that case, there was another condition that he violated. He never reported to probation upon release. It does not appear that he ever enrolled in the next level boys academy. So those things that he was supposed to do, he did not do as a part of the plea, Your Honor.
All right, thanks for that clarification.
And Your Honor, we can give a recommendation now, or your recommendation.
Yeah, I'd like to hear your recommendation. I'd also like to hear what his criminal history is right now, other than what we've already discussed, because I believe he's maybe got some other convictions.
No, Your Honor. So his only criminal conviction now is the robbery. He was revoked. His first offender was revoked, Your Honor, and he was resentenced on April 22nd, 2022, and he received 45 years to serve on the resentence, Your Honor.
All right.
And he had juvenile history, Your Honor.
What's his juvenile history?
We do not have the juvenile charges here with us.
Okay. What's the state's recommendation?
Your Honor, the state's recommendation is to add count 1, conspiracy to violate the RICO Act, 20 years to serve. As to count 27, armed robbery, 20 years to serve, concurrent to count 1. Count 29, possession of a firearm by first offender probationer, 10 years to serve, concurrent with count 1 and 27. Theft by taking, 5 years to serve, concurrent with count 1, 27 and 29. Attempted murder, count 32, 20 years to serve consecutive to count 1, 27, 39, 31. Count 33, attempted murder, 20 years to serve consecutive to count 32. Possession of a firearm by first offender probationer, 10 years to serve, concurrent with count 33. Possession of a firearm during the commission of a felony, 5 years to serve, consecutive to count 33. Count 39, participation in criminal street gang activity, 20 years to serve, concurrent with count 33. Count 47, conspiracy to commit a crime, 10 years to serve, concurrent with count 39. And count 48, participation in criminal street gang activity, 20 years to serve, concurrent with count 39. So that means 65 years to serve. We're asking that to be conserved consecutive to his probation violation, which is 16 SC 143618.
143618.
Yes, Your Honor. And Sergeant Johnson would like to address the court at the appropriate time.
Alright, you can do that motion.
I'm sorry, Your Honor.
You can do that now.
Morning, Judge. Appreciate your time. Had a few minutes to discuss this.
Okay, Chairman, do you want to take the witness stand? That might be easier. Okay. Yeah.
My name is Will Johnson, WILLJOHNSON. I'm a sergeant with the Atlanta Police Department, Homicide Unit. At the time of this event, I was a detective with the APD Gang Unit. I was operating undercover capacity, just kind of laid out the event. I mean, you've seen the video. And just my background, I've been in the department for 18 years. Prior to being in APD, I was in the Army. I was in the 75th Ranger Regiment. I have 4 combat deployments. I've been in firefights, gunfights, grenade fights, rocket attacks, IEDs, car bombs. I've had a lot of experience with trauma. I think this is the most traumatic event that I've ever experienced in my life. And I think it's not because of a gunshot, somebody getting shot, or I see this all the time. It was just the intent and the act. It was an execution. It wasn't an attempt to get away. It wasn't a fight or flight type, or it wasn't a flight in the fight, right? He was trying to fight. He wanted to kill this officer, and he made every attempt to do it. He didn't take a shot and run. He stood there and fired round after round after round into Officer Rogers, and it was probably one of the most helpless events that I've ever experienced. And he didn't even run until he started getting shot at, and then he fled like a coward. And so I think about this day all the time. It comes back and forth in my brain all the time. I know with Officer Rogers, he does the same, and it's probably not going to change. I think back to like when I approached him. I remember like the look on his face, and I've seen that look so many times, and it always ends in death. And so when I looked at David, I thought, yeah, there's no way he's gonna live. There's no way. He had that glassy look, that stare that was just gone. The light was out, and we tried everything we could on scene. He was shot so many times. So there's so much blood. I remember there was just so much blood. I could taste the blood, the iron in the blood. Like I tasted it for like 2 days. And so I remember my clothes. I was just like, that was the other thing. I remember I was just covered in blood, like from chest down. I'm sitting here covered in blood, and I'm sitting here for like hours afterwards, covered in this blood, smelling this blood, and waiting to make statements and everything, and not even knowing how he was doing. I'm thinking he's dead, and this guy just got away with it. And so I guess I'm just here to ask you. I mean, so like our ability to do this job, and when I go to work every day and put on this uniform and kiss my kids goodbye, like we don't know if we're coming home. And we accept that to an extent, right? That's kind of part of our job to just be prepared for that. But our ability to do that is backstopped in the belief that you, Judge, and the courts are going to show up for us the way we show up for you. And so that's basically what I'm here asking, is for you to show up for us and to provide whatever, I didn't even catch what the max was, but whatever the maximum sentence that you could provide would be appropriate in this offense.
All right, I appreciate you sharing that.
Thank you.
Officer Rogers is present for anything I want to say.
Yeah, and I actually recall Officer Rogers' testimony from the prior trial. All right, Mr. Johnson.
Yes, Your Honor. Before you stand, Mr. Christian Eppinger has been before the 25-year-old lifetime amount of resident, Your Honor. And as an attorney, I want to thank you for the opportunity to provide this plea today, the opportunity to represent Mr. Eppinger. As an attorney who was here from the beginning of the first trial, I have a unique perspective of this entire case, Your Honor. And I just want to extend my appreciation to all the members of the state and their tireless work on this particular matter. Your Honor, however, we must say, this entire case, as evidenced by the state's recommendation and as evidenced by the officer who just testified, this entire case has been a witch hunt against Mr. Eppinger solely because he was involved in a situation with an officer. The reason I say that is the state just presented to you a timeline of events. If we go back to the first event in 2016, Your Honor, Mr. Robbie Hill testified at the original trial. In that case, and nowhere in the discovery is there any mention that the other individuals that were with Mr. Eppinger, that they were affiliated with YSL, that Mr. Eppinger was wearing any red clothing or anything else, that Mr. Eppinger had the YSL tattoo on his face. The car was recovered shortly thereafter, so there is no showing that this automobile was stolen to benefit, profit, or to help YSL in any way.
All right, now that's the 16 SC case.
Yes, Your Honor.
That's already been taken care of.
What I'm saying is, Your Honor, that is alleged in this case as Act number 61 for the RICO count. So what I'm saying is, they are alleging that that is part of the RICO, and there is no allegation whatsoever or any facts that my client was affiliated with YSL at that particular time. So moving forward to the other incidents on this case, Your Honor, there's a situation involved, the October 12th armed robbery in this case. And we'd like to point out that my client is charged with these particular offenses. And it also is evident that, as I said, the state is attempting to get Mr. Eppinger because there was a co-defendant on these charges as well, Your Honor, Mr. Durante Beebe. And the state recommended a sentence of 10 certified for Mr. Durante Beebe for these charges. And I think that is very important because Mr. Durante Beebe was the individual who was immediately identified by the victim in this case. He was identified some by his facial features, but also by physical disfigurement on his hand. And it's important to point out that the victim in this case, Mr. Darius Hill, who would have testified in this case, additional evidence would have come out that his initial report to the police officers, he gave a description of an individual that did not fit Mr. Eppinger's description. In his first conversation with the officers, when he went to the police officer, he identified another individual as being the person who perpetuated the crime. He stated that he was given that information because this was word on the street. So there was no viable information to identify Mr. Eppinger as a participant in this crime. Later, the officer who would have testified as Matthew John Pierre, who was the lead investigator on this case, Your Honor, he would have testified that they received an anonymous tip telling them that Mr. Eppinger had been involved in this situation from a person who alleged to have viewed the robbery. Your Honor, the witness in this case testified that the individuals who perpetrated this robbery were wearing masks and he could not identify them. So it's very hard to say that an anonymous tip who says that they saw this in masks would have been able to identify Mr. Eppinger. That is why Mr. Eppinger's name was involved in this particular case. And subsequent to that, the witness went in to meet with the police officer to identify a photo lineup. Mr. Eppinger was identified in that photo lineup. However, Your Honor, the video, if this matter went to trial, the video of that interview would have shown irregularities by Mr. Matthew John St. Pierre in conducting this lineup, where when presenting the information to the victim, he took Mr. Eppinger's picture from the bottom of the stack, placed it on the top out of order, and then shoved it in his face for him to make a selection, at which time he picked Mr. Eppinger. He had no prior information regarding Mr. Eppinger. He did not know Mr. Eppinger or anything else like that. And that is very important, Your Honor, because the state in this matter is alleging that a video that you heard Mr. Eppinger that was made on October 16th is him bragging about this robbery. In that video, you hear him saying that, you hear Mr. Eppinger saying that he has contacted a person attempting to sell something or whatever. That is important because that video was made on October 16th. The identification of Mr. Eppinger was not made by Mr. Hill until October 20th, Your Honor. And at no point in his conversations with him had he mentioned that he had been contacted by the person who tried to, who had robbed him, that there was an attempt to sell back anything. And then also, Mr. Eppinger on the video stated that the person he was attempting to sell the chain to was coming from Henry County, and Mr. Smith states that he lives in Forest Park. So he would not have been coming from Clayton County, Your Honor. So there are numerous inconsistencies. Nowhere in that video is Mr. Eppinger mentioned being involved with a co-defendant in conducting this robbery, as Mr. B. We know Mr. Eppinger is present. Nowhere does he mention conducting a robbery with another individual, and nowhere does he mention taking a van or anything. And also, Your Honor, in that armed robbery, that van was recovered shortly thereafter too, so there is no showing that the van was taken to be sold for YSL benefit, to be sold for YSL transportation, or to benefit anything other than possibly the individuals who took that car taking it for a joyride at that particular time. Mr. Smith testified that his car was ransacked, but it was not damaged, so there were no items stolen off of his car or out of his vehicle.
And that's the count, one of the counts that's being not crossed, right? The hijacking motor vehicle.
Yes, Your Honor.
But it goes to the armed robbery, Your Honor. It's very important.
I understand, I'm just trying to make sure I got it all.
Because, Your Honor, why that's very important is because, as I stated before, Mr. Beebe, the co-defendant of these charges, he was allowed to plead to a reduced charge of robbery and given a 10 to 5 cents in this case. The fact that the state is unwilling to do the same with the co-defendant in this matter, Mr. Eppinger shows their intent toward Mr. Eppinger wanting him to serve the mandatory minimum on the armed robbery sentence, which, given in light of the probated sentence that he has right now, is a mere formality unless it's run consecutive, Your Honor, I'd like to point out. And Mr. Eppinger probation was revoked, as the state stated before, correctly. He did not have any provision that he was supposed to stay away from any gang members because there were no gang charges in his first crime. And the allegation that he was supposed to stay away from individuals of ill repute or harmful character, Your Honor. The individuals that hang with are individuals in his neighborhood. He was a 17-year-old child. So I'm sure he does not know the criminal records of everyone, of all the children and teenagers in his community. No, I'm not supposed to be with this guy because he's a harmful character or anything else like that. But we'll point out, prior to this incident that involved the police officers, there had been no revocations of Mr. Epinger's probation or no other arrest warrant. He was arrested for this, and all of this came to light. Now, Your Honor, you saw the video, as stated before, we go back to finish up on the armed robbery situation. As I stated before, Your Honor, if the matter did proceed to trial, we do believe that there will be sufficient inconsistencies with Mr. Smith's testimony, numerous things that could possibly invalidate his identification of Mr. Eppinger in this particular case. To just point out these additional facts, while we do believe that they are present, they may not be enough to carry the day, which is why we believe that this plea is within the best interest of our because we do not believe that the state's presentation of these facts are 100% accurate and that their evidence is 100% solid. We do believe that Mr. Eppinger does have a defense in this matter, but the uncertainty if this matter was presented to trial is the reason in which we say that this matter is within Mr. Epinger's best interest.
Okay, and a part of Alford is essentially an acknowledgement that while you are not conceding guilt, you are acknowledging that there is sufficient evidence from which a jury could conceivably find guilt beyond a reasonable doubt, correct?
Yes, Your Honor.
And you've discussed that with Mr. Eppinger.
Yes, Your Honor.
And Mr. Eppinger, you agree that the facts are such that a jury might find you guilty of all of this? All right, go ahead.
So, yes, Your Honor. And we would then like to proceed to counts, the most important counts in this case, counts 32 and 33, involving the attempted murder in this situation. Your Honor, I've practiced law for over 20 years now. Majority of the times when an individual is shot or shot at, that's an aggravated assault. Most times. In this particular situation, the state has chosen to step into the mind of Mr. Eppinger and say that he had the intent to kill these officers. In this particular situation, charged him with attempted murder. One officer who was not even struck by any bullet or anything else like that. So we do believe that he has been overcharged simply because the district attorney's office, from the beginning of this case, has used inflammatory language and rhetoric in this particular matter. In the initial interview, in the initial press conference regarding this situation, they said that Mr. Eppinger attempted to assassinate this officer. As you heard the video yourself, Your Honor, you saw what happened. The matter happened in a matter of seconds. There was no pre-planning. Mr. Eppinger wasn't out there trying to get anybody. He didn't know anything about this warrant. He didn't know that they were looking for him. He had no idea any of this was going on this particular day. Because as he contends his innocence from not participating in the armed robbery, Your Honor, he would have had no idea that there was a warrant for his arrest. And you heard on the video, at no point in time did Officer Rogers identify himself. At no point in time did he say, I have a warrant for your arrest. If you heard the video on the first trial, you heard it again today. At no point in time did he say that. And Your Honor, would also like to point out that at no point in time, excuse me, do you have a speaker? And Your Honor, one thing about it, and I'm going to show the state marking as defense exhibit number 1 for the purposes of the hearing, Your Honor. You have heard numerous times that at the time of this shooting that Officer Rogers was uniformed. That is incorrect, Your Honor. That is a blatant fallacy. If I may provide to the court exhibit number 1, I'll show to the state. Your Honor, this is a photograph that was taken from, that is a capture, that is taken from the body camera of Officer Storner, who the state has admitted was present at the scene. And that is a picture of Officer Rogers laying in the grass after the officers had moved him to a safe position after he was shot. As you can see, he is wearing a hood, he is wearing a mask, and he does not have his badge on the front. He was not in his full uniform at the time of the shooting. In no shape, form, or fact. That is what Mr. Eppinger saw that day, Your Honor. He did not see an officer in his uniform, as been said numerous times. He did not have any of the uniform that the officers were wearing that day. He was in an undercover capacity who charged out of his vehicle as Mr. Eppinger.
Out of his marked patrol vehicle, right?
From behind, Your Honor. Yes, I admit that it was a marked patrol vehicle, but he approached Mr. Eppinger from behind, ran out of the vehicle with his gun drawn, attacked Mr. Eppinger, did not follow police procedures. He did not identify himself as being an APD officer. He was not in his uniform, and he at no point in time did you hear me say, we have a warrant for your arrest. You heard him one time say, you got paper. However, Your Honor, we will contend, and I'm sure the evidence will show from the gang experts that will testify in this case. On the street, paper does not mean warrant. Paper means money. So therefore, saying you got paper was not indicating or giving Mr. Eppinger any knowledge that he has a warrant for his arrest. And any indication is shown, Your Honor, at his prior arrest, his prior conviction, when he was arrested before, he was taken into custody without incident. The officers informed themselves, showed him that he was taken into custody without incident, so the state cannot allege that, oh, he's just this big bad person who attacks police officers. Subsequent to this, as the officer testified that, oh, we thought that, well, he was going to get away with this, that officer was at the hospital at the time. He had no knowledge that Mr. Eppinger didn't even leave the complex. He was taken into custody. Probably by the time that they had gotten to the hospital, Mr. Eppinger was taken into custody. So
After the house that he was hiding in was surrounded by officers, correct?
Yes, he was taken into custody without incident at the time. He attempted to hide. We admit that. He attempted to hide as a scared child at the time. And therefore was taken.
How old was he at the time?
22. Your Honor, so in this particular situation, as stated before, the officer did not follow his procedures in doing so. And Mr. Eppinger did not know he was an officer at the time that he was attacked. When he came out, he had his gun drawn on Mr. Eppinger. So it's safe to assume that Mr. Eppinger's focus would have been on the gun that was presented to him in the scene order. Get on the ground with the person not identifying himself. So we do not believe that this is a situation where he was intending to kill anyone, and Your Honor, taking into consideration that this matter, this entire case, is a 65-count indictment that has been levied down, Your Honor. And in this matter, there were 2 counts of murder, another count of attempted murder in this matter outside of Mr. Evans. All of those matters have been reduced by the state. All of those matters have been reduced. So what the state is saying is that the lives of their citizens are not as important as that of police officers, because we'll reduce the murders of people who we know are murdered, but we're not going to reduce for the purpose of the plea for this particular matter for Mr. Evans.
All right, 15 of the counts are against your client, right?
Yes, Your Honor.
Okay. And at least 4 separate incidents against your client, right?
In this particular matter, yes, Your Honor.
Okay.
Four separate incidents, Your Honor. And I point out, in none of these situations has anyone died in any of these situations. Now, as it relates to the theft by taking, Your Honor, that matter, as it relates, I spoke to Mr. Evans, is probably the matter in which he has the least amount of defense or facts in his favor. It's not, the video is pretty evident. You see Mr. Evans from the video into the vehicle, so we'll move on from that. As it relates to the last matter, Your Honor, the issue involving the conspiracy. You heard Mr. Evans on the telephone make a phone call, and the state is interpreting. Never does he say anything about Mr. Bennett. Never does he say anything about killing Mr. Bennett or anything else like that. The state is making the assumption that these is what his words mean. However, the facts are, as stated before, he was speaking to Mr. Antonio Sumner. Mr. Sumner and Mahmoud's matter of these charges before he received 15 years of probation for this particular matter. We do not believe that there's any evidence to show that any call was made to Mr. Williams to get Mr. Evans an attorney or anything else like that, or anything was done, or there was any substantial step based on that initial offer to do anything, if it is to be construed as an offer. Our contention from the defense would be that it was not an offer, just a conversation, but the state is saying that he was offering his services to possibly attack Mr. Bennett, and they assume that it's the murder of Mr. Bennett, Your Honor. However, there's no showing that Mr. Evans has ever made an attempt on Mr. Bennett's life, that there was any kind of order given down from the top or passed through any other parties or anything else, that there was an agreement between Mr. Evans or anybody else to harm or attack Mr. Bennett. So as such, in this particular matter, taking into consideration the fact that Mr. Eppinger is currently serving the revocation of his probated sentence for these particular acts right here, Your Honor. His probation was revoked solely because of these acts.
Okay, his probation was revoked and he was resentenced.
Yes, Your Honor. He was originally resentenced to 66 years. That matter was appealed and reduced down to 45.
All right.
And so, Your Honor, for these particular facts, like I said, there are issues with regards to Mr. Smith's identification of Mr. Eppinger as it relates to the armed robbery and the hijacking charge, Your Honor. As it relates to the attempted murder, Your Honor, I do not believe that there's a requisite intent to kill in this particular matter. It's shown it out. The state is intending, the state focuses every time that Mr. Officer Rogers was shot 6 times. 4 of those shots were in the shoulder, Your Honor, in his right shoulder, 1 in his leg, and a grazing wound in the back of his head, which is not meaning that that came from a direct shot, given the fact that placing him where his wound was in the back of the head. That bullet could have been introduced through medical evidence that the bullet could have ricocheted off of his shoulder, which was shattered by being shot 4 times, and possibly grazed the back of his head, Your Honor. If you look at the video, at no point in time is Mr. Eppinger behind Officer Rogers to shoot him in the back of the head. So therefore, a direct shot, we know he did not shoot him directly in the back of the head whatsoever. Eventually, it was a grazing wound that went past the back of the head, which is not determined as exactly how that may have happened, Your Honor. Yes, one before you heard Mr. Eppinger, the state brought a phone call of Mr. Eppinger at jail and said, laugh, when they put on the screen, laughing about attempting to murder. Your Honor, that is basically a far-fetched to say what Mr. Eppinger's intent was during this conversation on his telephone with this other individual. It's not that he intended to murder this individual. He had no knowledge as to whether or not this officer was dead. He shot him in the shoulder. At no point in time, given the close proximity that they were, at no point in time if Mr. Eppinger wanted to kill this officer, he could have shot him in his chest or he could have shot him directly in his head. There was nothing preventing him from doing that, nothing.
Maybe he's a bad shot.
Or Your Honor, or maybe he's a good shot. The fact that he was pressed forward in the shoulder, that shows a very tight movement, Your Honor. We're not gonna get into that. However, the individual was shot, Your Honor. But at no point in time did he shoot him in any vital organ or anything else like that. As far as the shot in the leg, Your Honor, the most damaging part of the shot in the leg would be if the bullet would strike the femoral artery. Given the fact that the average human thigh is approximately 7 to 8 inches, Your Honor, and the femoral artery is approximately 10 millimeters in width, there's no way that he could intend to hit that particular, by shooting it, I'm definitely gonna hit the femoral artery in an attempt to try to kill somebody, Your Honor. So, saying that Mr. Eppinger was attempting to try to kill anybody in this situation, we do believe is a stretch, especially in light of the fact that the officer is not in uniform at the particular time. Also, Your Honor, we'd like to point out that in this particular indictment, we do believe that this entire case, and I can say this now, culmination of it, has been somewhat of a witch hunt, Your Honor. This case involved a 65-count indictment with 1 count of RICO. That leaves 64 other counts. There was 21 possession of firearm charges and not 15 gang charges, Your Honor. So therefore, if you look at the remaining charges in this case, there are 15 charges involving violence over a 7-year period. 15, Your Honor. There were 3 counts of attempted murder, 2 counts of murder, 4 counts of armed robbery, 2 counts of hijacking, and 4 counts of aggravated assault alleged in this entire indictment, Your Honor. And all of the murder charges and all of the armed robbery charges have been reduced to either aggravated assault or robbery. However, the state is unwilling to do so on behalf of Mr. Eppinger. We'd like to point out, as they allege in this matter, that YSL is a criminal street gang, Your Honor. I'm sure that if the evidence, if this matter proceeded to trial, each one of the gang experts would testify that association or membership in the gang in and of itself is not illegal, Your Honor. So the fact that Mr. Eppinger may have been seen posing with individuals on Instagram or may have been wearing a certain type of clothing in and of itself is not criminal. There is no showing that any of the crimes alleged by Mr. Eppinger have been tied in back to YSL in any way other than his alleged membership in them, Your Honor. They have furthered the interest of the gang in any way, financially, status, or anything else. Ms. Hill, the victim of the first armed robbery run, was not shown to be an adversary or anything of YSL. Mr. Smith, the individual who was robbed in October 21, was not shown to be an adversary of YSL, or that this was done to further YSL in any way, Your Honor. And so therefore, they allege that YSL operates over the Cleveland Avenue area, which is in Zone 3, Your Honor. So before I became a lawyer, I used to be a scientist, Your Honor. So I took out my legal hat and wanted to look at the numbers and look at things analytically, Your Honor. In this particular situation, in Zone 3, which is allegedly the YSL stronghold, over the life of the RICO from the time that they allegedly began on January 24th, 2013 to the time of Mr. Williams' arrest on May 8, 2022, there were 239 murders in Zone 3. However, citywide in the city of Atlanta, there were 987, so therefore, the murders in Zone 3 only represent 24% of the total murders in the city of Atlanta. As it relates to armed robbery, Your Honor, they only had 19.8% in Zone 3. As far as auto crimes, as far as auto theft, only 19.6% of the total crime in Atlanta. Aggravated assault, Zone 3, where they allege the YSL stronghold only represents 25% of all the aggravated assaults in the city of Atlanta. So these 7 events of violence in this case, 2 of which are associated with Mr. Eppinger, occurred over the course of 7 years. From January 10, 2015, which was the murder of Mr. Donovan Thomas as alleged in count 2, to March 14th of 2022, which was the alleged murder of Mr. Chanel Prince in count 49. There were these 7 events that we were referring to in this situation. So we contend that, as it points out, that Mr. Eppinger was our first offender probation, so he did not have an extensive felony criminal history before this.
Because he'd been a juvenile before that.
Well, you already also, speaking of felony criminal history, not access to the juvenile.
court's supposed to be able to have access to it for sentencing purposes.
Well, Your
It
Honor,
just hasn't been presented. But what I'm saying is, yeah, I understand that the 2016 armed robbery reduced to robbery, and now that he's been resentenced on was his first felony conviction. But you also, unless you commit a limited number of crimes as a juvenile, can't have a felony history until you pass a certain age.
well, we'd also like to point out, Your Honor, that at the time of their arrest on this situation, the person who was the co-defendant with Mr. Eppinger had many more arrests and more convictions at the time. Like I said, he was sentenced to 10 July on that matter. And Mr. Sumlin had more arrests than Mr. Eppinger also, he was given 15 years probation reduction. So moving to what we believe is a proper representation in this case, Your Honor. Given the fact that the state is enforcing Mr. Eppinger basically plead to everything in this particular matter. As the count one,
All right, hang on. The state's not forcing Mr. Eppinger to plead to anything. I've got a jury waiting next door, and we can strike a jury right now if he'd like to go to trial.
what I mean by that, Your Honor, Mr. Eppinger wants to take a plea. Mr. Eppinger believes that the plea is in his best interest, Your Honor. We believe that the court will be consistent with their rules and consistent with the fairness that they have shown throughout the course of the trial. So we believe that that is in Mr. Eppinger. That's the interest to do so. What I mean by saying that the state is forcing it, Your Honor, there have been numerous plea negotiations in this case, negotiated pleas and non-negotiated pleas, Your Honor. In fact, there have been, 25 pleas that were taken in this case, as only 2 individuals went to trial to verdict. So there have been 25 pleas taken in this case or dismissals in this particular matter, Your Honor. I'd like to point out that none of those pleas did any individual receive any sentencing to run consecutive to sentencing that they already had, Your Honor. I believe the most stringent one was the last plea that was taken from Mr. McMullen, who was given 40 and 20, and that was going concurrent with his current sentence that he has right now. So, taking that into consideration, what I mean by saying forcing is the plea that, I'm not saying they're forcing, but the state has been unwilling to negotiate with regards to the reduction or the dismissal of certain charges, as they have with other defendants.
Okay, well, my recollection is that the last offer by the state was to 2 consecutive life sentences, so it seems to me like they've definitely come down from that.
Well, no, the 2 consecutive life sentences was informed Mr. Eppinger what the maximum was. The first offer that we were given in this round of they started with your offer.
Okay.
Was life consecutive. Then they came down to 6 consecutive, then it was 40 consecutive.
All right, well, I hadn't been privy to all of that. The last one I heard was, okay, 1 and not 2 life consecutives, but it sounds like they've been coming down the whole time.
And now
All right.
we're 65 consecutive.
Okay.
Um,
Yes.
As it relates to count 1 for RICO, you would ask that my client be sentenced to 15 years to serve concurrent to count number 32. As it relates to count 27, Your Honor, the armed robbery, you would ask that my client be sentenced to serve 10 years to serve concurrent with count 1. The hijacking charge, count 28, is in Gold Cross. As it relates to count 29, possession of firearm by a first offender, we would ask that he be sentenced to 5 years to serve consecutive with count 27. The theft by taking charge, Your Honor, we would ask that my client be sentenced to 17-year maximum, be sentenced to 5 years to serve concurrent with count 1. Your Honor, as it relates to count 32, the attempted murder, Your Honor, we would ask that my client be sentenced to serve 20 years to serve 15. We do not believe that there was an intent to murder the officer, Your Honor, so we believe that this is more in line with the factual basis of that where assault in this case. So we ask him to serve 20 to serve 15 on that particular matter. As it relates to count 33, the attempted murder, Your Honor, we would ask that he be sentenced to 10 years to serve 5 concurrent with count 32. That reflects the fact that the other officer in this matter did not receive any injuries, and there is no showing on the video that he was ever in danger of receiving it. They allege that Mr. Eppinger shot at this officer, however, Your Honor, it is not apparently clear from the video that he did so, and we did not receive any information that the car that he was in was behind was struck by any bullets or any projectile was found from him, Your Honor, so we do not believe that the 2 counts and counts 32 and 33 are factually the same. That is why we made a difference in the resolution 26, possession of firearm by a felony, that's a hard sentence of 5 years to serve, concurrent on count number 27. For count 37, being low cross, it is being low cross. For count 39, Your Honor, we ask that my client be sentenced for the violation of gang law, Your Honor. We ask that he be sentenced to serve 20 to serve 15. Concurrent on count number 32. For the conspiracy act, count 47, Your Honor, we ask that my client be sentenced to serve 15 years probation, concurrent to count number 1. And for violation of the gang act, we ask that count 48, my client be sentenced to serve 15 years probation, concurrent to count 1, which based on the estimation we believe is a total sentence of, I think, 25 to 15, Your Honor.
Sure.
And I think that this is, like I said, fair with regards to the resolution of this matter, Your Honor, consistent with, as I stated before, on counts 27 and 28, the code of Defendant received 15 to 5, and 5 was a consideration because this matter was reduced from armed robbery to robbery. As it relates to counts number 47 and 48, the code of Defendant on those matters, Mr. Summer, received 15 years probation on those counts, Your Honor. So as far as anything that would be varying from those charges as it relates to the charges of the shooting of the officer, as I said before, we asked that my client be served 20 to serve 15, and that this matter run concurrent with his probated sentence right now, Your Honor, which we believe that is fair and consistent with what's happened with the other matters in this case, Your Honor. But at no point in time has there been any allegation that Mr. Eppinger was the organizer or leader of this situation. No other defendant in this matter received more than 20 years to serve, and includes individuals that were already charged with murder in this case. All the murder charges will be reduced to aggravated assault and double cross. And all of the armed robbery charges in this case, Your Honor, will reduce to robbery. The individual who received the hardest sentence on those was Mr. Huey, who had 3 armed robberies that were reduced down to robbery. He received a sentence of 20 to serve 9, Your Honor. And I would like to point out that in none of these situations, there is no one who has lost their life in any of these situations that this matter has been involved in, Your Honor. And so we do not believe that if Mr. Eppinger is not taking his life, we do not believe that there should be a second sentencing in this matter, which is effectively taking Mr. Eppinger life away from him, as he currently has a 45-year sentence, and a second sentence would basically effectively almost be a death sentence in this matter, Your Honor, which would put him further. The state's recommendation would give him 110 years to serve, Your Honor, which is effectively a death sentence for an individual who did not kill anyone. And so therefore, while we can sit and say that individuals may think and say that, oh, well, I think the officer definitely has his right to say that he felt that Officer Rogers was going to expire based on his injuries. The facts are, none of the injuries that he sustained were life-threatening. He was back in service sometime after he was able to come to court and testify, Your Honor. I believe he's on the force now, so he's resolving his activities, Your Honor. So if Mr. Eppinger has not killed anyone in this matter, he's standing before you today accepting the responsibility of the situation. You understand that, as I said before, there is a factual basis that the facts as presented by the state may present enough for a jury to convict him. We do believe that we have facts that could possibly go the other way as well, Your Honor. It is the uncertainty of that matter in which Mr. Eppinger seeks to avoid. He's under the understanding that if he was found guilty at trial, his fate would be in your hands, Your Honor. We stand in that position as we are today.
Thank you.
Just a few things, Your Honor. I want to correct the record. So I'm going to show Your Honor State's exhibit now.
You may.
State's exhibit number.
Have you shown it to opposing counsel?
Your Honor, showing State's exhibit number 1, Your Honor, which is Officer Rogers' vest. The video that Mr. Johnson showed you was after they took the vest off of him to perform life-saving services on Mr. Rogers. So you can see on that picture, there's some blood markings on Mr. Rogers' front of his badge. And we also have some pictures that we can show. Well, they were checked out the Zoom, but shown on the Zoom that has blood on the back of his vest, Your Honor. So when he got out of the car, his vest was on. He shot him in the vest, and so they took it off to help perform the measures, Your Honor. So that is an incorrect statement that Mr. Officer Rogers did not have or was not in uniform because he was in his vest that says,
It had the seal and his name.
his name on it,
Right.
right? Going to,
Defense Exhibit 1 and State's Exhibit 1 are admitted.
going briefly to the armed robbery, Your Honor, regarding Mr. Eppinger and this comparison of Mr. Beebe and Mr. Eppinger. When we spoke with Mr. Smith, Darius Smith, in preparation for this case, what he advised is that Mr. Eppinger was the individual informing or controlling the armed robbery. He was the one telling Beebe what to do, that Beebe seemed afraid or scared. And so when we made the decision for Mr. Beebe, we took that into consideration because that is what the victim told us, that it seemed as though Mr. Beebe was afraid to do it, but he was following the demands and the controls of Mr. Eppinger, which you can hear when he's bragging about it, what he said he did and how he spoke to the victim, Your Honor. So we took that into consideration when looking at Mr. Beebe's resolution. And Mr. Beebe did not have a prior armed robbery, reduced a robbery, when we decided to make that recommendation. And then as it relates to the stabbing of Mr. Bennett, the reason why Mr. Bennett was stabbed is not because he didn't have the opportunity, but because one of the law enforcement in our office heard the jail calls. They called the jail to have Mr. Bennett moved so he wouldn't be stabbed again. So it's not for the fact that he didn't do it, it's the fact that we were able to move Mr. Bennett to safety so that he did not get harmed again. So this notion that he didn't do is because he didn't have the opportunity. Your Honor, we were able to get Mr. Eppinger juvenile history, Your Honor. So he had 2 burglaries, one from June 4th, 2015, which was almost a year prior to the armed robbery. And then he had another burglary on February 11th, 2016, so a few months before the armed robbery. He was adjudicated, it looks like the date is May 11, 2016, so we're not sure. Once he was taken into custody, they adjudicated it, but they were joined for the purposes of the juvenile adjudication, Your Honor. Your Honor, my closing remarks here is that Mr. Eppinger is not similarly situated to many of the other defendants in this indictment. Mr. Eppinger received an opportunity to change his life when he got an armed robbery that he did at 16 reduced to robbery. He served 4 years in custody, and within 4 months, not a year, within 4 months, he was back to the same criminal behavior that they tried to save him from 4 years prior to that. He never learned his lesson, not once. And what does he do? He robs somebody. Then when police are just trying to do their job, he takes a gun that he's not carrying his waistband. He's not carrying where he has to pull. It's literally tucked under his arm with easy access and begins firing off rounds over and over and over again. Like you said, Judge, he's not a good shot. But bullets have no names. You know, Mr. Johnson just said, well, the bullet that went to Mr. Johnson didn't hit him. That's not, they don't have any names. And for that reason, Your Honor, the state, we believe, has been gracious in our offer. Mr. Eppinger, looking at what he's charged with, he's looking at life plus 150 years. That is what the maximum sentence is for the charge that he's pleading to. The state, understanding that he already has 43 years, which most of that will be door to door, consider that 60 years consecutive is about 103 years. And that is why we made that recommendation, Your Honor, given that we believe that is substantial time in this case. So, Your Honor, the state is going to ask that you follow the state's recommendation. Mr. Eppinger had an opportunity to change his life around, had an opportunity to go to the next level boys academy, had an opportunity to do all these different things, but he chose not to do that. He chose to go back into the streets, to live this life again. And here's where we are, and this is what it brought him to. And he had no remorse about it. On the jail calls, he's bragging about it. That's what he's doing. He wants to be this person in the streets. So we're asking you to hold him accountable to be that person in the streets.
All right.
That was fine.
Yeah, go ahead.
Here's one. First of all, as far as the allegation regarding the differences in Mr. Beebe no photographs of Mr. Eppinger wearing the train. And so therefore, the fact that they say that the witness told them that the one person was running it, we do believe that the evidence that he's getting in his interview, we don't have a recording of what he said when he was in their office. However, the recording that he gave to the police officer at the scene of the crime, the recording that he had with the officers later on, and the recording with the officers at the time that he made the identification says none of that, Your Honor. So therefore, that evidence in and of itself should not be taken as 100% credible. It's subject to cross-examination and discrediting as well, Your Honor. So therefore, the state has not shown a significant difference between this situation, as Mr. Beebe is the individual that photographs wearing the chain after the incident, which would show that he's much more involved in just being a scared person standing on the sideline. He's the one with the spoilers of the crime, Your Honor, and the state has evidence of that they knew at the time they gave his plea. Also, Your Honor, as they mentioned about the fact that Mr. Defendant was moved, the state still has not said any evidence that there was any agreement for Mr. Eppinger to do this. There's no showing that Mr. Eppinger had received an order or any kind of compensation to do this. So the fact that they moved him is irrelevant, Your Honor, because there's no showing that the crime of the conspiracy was actually completed in this particular situation, Your Honor. So the fact that they may have moved Mr. Bennett and Mr. Eppinger did not complete the crime is irrelevant, Your Honor. The issue in fact in the matter is not whether he actually did it, whether or not there was an agreement prior to that for him to do that sufficient for the charge of conspiracy, which they have not done so in this particular case, Your Honor.
All right, thank you. I found there to be a factual basis for this plea, and I will accept the plea as freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences and the sentence. And let me say a couple of things. Only one overt act, as we all know, needs to be proven to establish RICO. On counts 27 and 29, I believe that the defendant's own words inculpate him in the crimes, and I note that he talked about telling the victim to take off the earrings too, which was a part of what was stolen in the case. That certainly seems to, in the court's estimation, inculpate him in those crimes as an absolute willing participant. 31, understandably, considering what we see on video, the defense has really not argued anything at all. Appreciate that, that y'all acknowledge that at least that is pretty clear. In counts 32 through 39, the video, in addition to State's Exhibit Number 1, shows the officer to be in uniform, and I do not think that charging attempted murder is an overcharge, considering that Mr. Eppinger, and we hear 6 shots on the video, pumped 6 shots at close range into a uniformed officer, and then laughs about it afterwards, including saying something to the effect of, yeah, he's telling me to get down, I ain't getting down. I think that considering the prior history, the number of different incidents, honestly, almost back to back to back to back, from him getting out on first offender probation and deciding he's not going to change his life, he's not going to take the opportunity he's been given, and many of these incidents wouldn't have occurred, or wouldn't have occurred with the seriousness that they did if he had abided by his first offender probationary condition of not having a firearm in his possession. He couldn't have shot an officer because he wouldn't have had a gun to shoot an officer if he had abided by his conditions of probation. So the number of the separate incidents, the apparent lack of remorse for any of this, the seriousness of the crimes, and the strength of the state's evidence on these particular charges, and the demonstrated determination to continue a criminal lifestyle all go into the court's sentence determination in this case. So the sentence on count 1 is 20 years to serve 10. On count 27, it is 20 years to serve 10 concurrent. 29 is 10 years concurrent. 31, 5 years concurrent with count 1. The sentence on count 32 is 30 years to serve consecutive to count 1. 33, 20 years to serve concurrent with count 32. 34 is 10 years to serve concurrent with count 32. I'm going to come back to 36 because that is required by statute to be run consecutively to anything else that's being sentenced. That's the only one that's that way, right, Ms. Hilton?
Yes, you're right.
All right, count 39, the sentence is 20 years to serve 15, concurrent with count 32. 47, the sentence is 10 years, consecutive to count 32, but probated. 48, 10 years, concurrent with count 47, probated. And then 36 is going to be 5 years consecutive to count 47 and probated. I believe that is, honestly, I'm going to have to do a little bit of math right here. I think that's 75 years to serve. To serve 40, followed by 15, no, but I don't know what the math comes out to be,
So
but
you said 20 to serve 10 on count 1.
20 to serve 10,
20 to serve 10 on
concurrent,
one concurrent.
10 to serve concurrent, 5 to serve concurrent with count 1. So that's a total of 20 served 10 right there. 10 probated. All right. Count 32 is 30 years to serve consecutive to count 1. So that's another 30 to serve. Count 33, 20 to serve concurrent with count 32. 34, 10 concurrent with count 32. So right now we're at 50, serve 30. Yes. If there's 30 to serve,
To serve 40. Because it's 20 to serve 10.
clearly this is why lawyers end up lawyers and not scientists or mathematicians, although that's your job. Yes, consecutive to count 1, which is 10 to serve. So that's 50 serve 40 at this point. Count 39 is 20 serve 15, concurrent with 32. So that's not any additional time to serve. So, and then 47 is 10 probated consecutive to 32. 48 is 10 probated concurrent with 47. And 36 is 5 consecutive to 37 probated. So that's,
Consecutive to 47.
yes. It's at least 65 to 40.
And would that run concurrent with his current sentence?
How long is he gonna actually serve on that sentence?
Our understanding is to say 40 days.
45 years.
45.
And run currently with his sentence he is currently serving. All right, that is the ruling of the court. And we are adjourned. He may be taken into custody.
Judge, is this Alfred to all of these counts?
I didn't know if there was some that weren't that.
It's every one of them.